Good morning, judges. I'm Gurneet Sohi, representing the appellant.
All right. You each will have 15 minutes to argue today. Dr. Sohi, you can reserve some of your 15 minutes if you wish for rebuttal. We will start with you, and if you'll approach the podium for argument, would you like to reserve any of your argument time for rebuttal this morning?
Not right this minute.
All right. Well, if you use your 15 minutes, that will be it, and you won't have any rebuttal time. All right. You may approach, and whenever you're ready, you may begin.
Your Honor, I have articulated all my points and arguments in my brief and in my reply brief. And I request the court that I may present them as what they are and my reliance on them, but I'll be happy to answer any questions you may have about this. Thank you.
Thank you. Does the panel have any questions this morning? All right, you will have several minutes remaining, 14 minutes remaining for rebuttal if you choose to use them.
Good morning. Please report, Dr. Sohi. As I stated earlier, my name is Robert Butler. I represent Sycamore Township. Two very simple issues in front of you. Well-settled law. Facts are fairly clear. First being whether the court erred in, and Sycamore Township erred in not joining two attorneys that were pursuant to the parties' settlement agreement, whether we erred in not joining them as parties to our motion to enforce the settlement agreement. That issue was not raised in the trial court, so it cannot be raised here. He filed his notice of appeal July 20th, 2021. They filed their motion to intervene, the final one, the amended one, on 1/4/22. So it was not raised for the purpose of this appeal. The second being the judge's allowance of Dr. Sohi's, or I should say the defendant's attorneys, to withdraw at the point of time where the motion to enforce the settlement agreement was being heard by the court. As the court well knows, that's an issue handled or controlled by abuse of discretion. There was no abuse of discretion. The motion to withdraw by his attorneys was filed 172 days prior to the hearing on the motion. He had plenty of time to take action, consult with other counsel, do anything. Rather than that, he stood up on the day of and he said, "I'm not ready. I need more time. I need a continuance." So clearly, Judge Triggs didn't abuse his discretion allowing the counsel to withdraw. But then look at what he did additionally. He also said, I'm ruling in favor of the township. He ruled in our favor. And he said, and Dr. Sohi, I'm going to give you another 30 days. I'm not going to put the entry of record. I'm going to give you another 30 days to take action, to come into compliance with the settlement agreement, or, well, he didn't say get other attorneys, but certainly he could have got other counsel had he chosen. So there was no abuse of discretion allowing the attorneys to withdraw. That's all I have, Your Honors. So if there are any questions.
Any questions from the panel?
Thank you very much.
Thank you. Dr. Sohi, if you choose, you have 14 minutes if you'd like to address anything raised by Mr. Butler.
The 2 points that the township brings forward are very well articulated in the brief and the reply brief, where within seconds I was forced to take a position and defend a motion that was then granted. And that is well argued here. Your reliance on authority, the two cases are presented in my brief. And most importantly, at that point, I did not know whether or not the court will grant the motion to withdraw two attorneys if they were not granted to withdraw, it would be wholly unnecessary for me to have a counsel. I had no idea how the court would rule motion to withdraw. And that is all articulated in my brief and reply brief. Thank you.
All right, thank you. Thank you both for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thank you very much.
Thank you so much.
Our next case this morning is the consolidated cases of State of Ohio versus Brandon Hare and State of Ohio X-Rail Brandon Hare versus the Honorable Heather Russell. These cases have been combined, consolidated for oral argument this morning. Counsel, we discussed ahead of time the panel among ourselves, and unless you all want to convince us otherwise, I think we can do this with 15 minutes per side. And perhaps, Mr. Sauter, Ms. Lapp, I don't know if you're going to divide the time or whether one of you is going to argue. And the first question is, do both sides think it's sufficient 15 minutes aside?
I'm in agreement.
Yes, Your Honor, that'd be plenty of time. We've discussed it. We'll split our 15 minutes, but I can't imagine we'll need it all.
All right. We will begin then. Ms. Gieske, would you like to reserve any of your 15 minutes for rebuttal this morning?
Yes, Your Honor, I would like to reserve 3 minutes, please.
All right, and whenever you're ready, you may begin.
Thank you. May it please the court, opposing counsel? There are two themes in today's consolidated argument. One is the basis of our interlocutory appeal, and that is where trial is already underway and the judge sua sponte declares a mistrial without soliciting input from the parties, without giving sufficient reasons, and without considering reasonable alternatives, that we submit that jeopardy does attach and bar retrial. The basis of the writ petition is that in order for the criminal legal system to function properly, the rules must be followed. When they are not, this court can exercise its supervisory jurisdiction to strike improper action of lower court. So I'll begin, unless this court directs otherwise, with the interlocutory appeal. The background principles of law are well settled. So jeopardy attaches in a bench trial when evidence has already been elicited, and in this case, cross-examination of the state's witness was underway. So the question becomes whether that jeopardy ended in such a way to bar retrial. In that respect, the Ohio Supreme Court Widner case says that double jeopardy precludes a second trial unless there was a manifest necessity to declare mistrial or the ends of public justice would otherwise be defeated. So when you look at the case
and how do we conduct that analysis when clearly there was nothing that the state did that precipitated this mistrial? I mean, this was wholly decided by the judge. No one asked her to do this. How do we analyze the manifest necessity and ends of justice?
Right, and I do have a suggestion for that. In the case of Klein versus Lice, that's 548 F. 3rd 425, the Sixth Circuit offered 3 factors for seeing whether something constitutes an abuse of discretion when the judge declares a mistrial. I think this is particularly helpful. The first factor is whether the judge heard the parties' opinions about the propriety of the mistrial. The second is whether the judge considered alternatives to a mistrial. And the third is whether the judge acted deliberately instead of abruptly. And I don't think you have to actually look very far on the record to see that none of these 3 were met. And, in every case where you hold jeopardy bars retrial, where the state did not occasion by, prosecutorial misconduct and goading, the state is going to be collateral damage. But jeopardy is the rule, not the exception, and that can't carry the day in every case. So Klein versus Lice gives us these factors to look through. And there's no colorable argument to be made that any of those factors were met.
Isn't it reasonable to conclude from this record, however, that the judge determined that she had such a bias that she determined she wouldn't be able to remain fair and impartial?
So, yes, Judge, 2 answers for that. One is the record doesn't actually say that. When the state argued at the dismissal motion and when Judge Bender ruled on the motion to dismiss, the state said, I believe it is a reasonable inference that, the judge said she was too biased or inferred she was too biased. Judge Bender said, she recited Judge Russell's findings and said, I take that to mean, Manifest necessity, it is an oxymoron to have to infer. Manifest necessity, like manifest weight review, it has to be a high bar, it has to be explicit, and under some of the same language, great caution, exceptional circumstances. So we submit that under those circumstances, you shouldn't infer.
Well, what is your case law that says we can't infer what
I
she
would-
meant?
I would say that when you read the seminal case on the mistrial is Arizona v. Washington. And when you read, it's cited in our brief, it's a U.S. Supreme Court case. And they talk about the phrase that they used is a heavy burden for manifest necessity. So again, it should be apparent from the record. And when you actually read the record, the judge didn't say that. She said, I don't like you telling me how to, what you can and can't do. We're not getting along. We would submit that it would not be respectfully good case law to hold that when attorneys disagree with the judge about the law, that is enough to rise to this high level. Because, there are multiple reasons. We want the lower courts to apply the law correctly. It furthers the administration of justice. Stare decisis is a very important concept. It affects how we, as attorneys, advise our clients, both civilly and criminally, every day. It affects how judges rule in the cases. So fealty to the law is an important concept. It is in the Judicial Code of Ethics. It is in the Attorney Code of Ethics.
But why else would the judge have abruptly ended the trial if she didn't believe that she couldn't be fair and impartial in this case?
Attorneys and, as people have sat on the lower court bench for a long time know, attorneys and judges butt heads sometimes, and there's the concept of zealous representation, which we also want our attorneys to do. That can give some rise to maybe, at most, some discord. We think the state engages in hyperbole when they say that counsel's tone was nasty. You have to actually read that into this record. If you just take the words for what they are, there were 3 disagreements on what the law was. And do we want to rule that when the court and attorneys disagree on the law, that should be enough to give rise to bias? That would be, we submit again, that's not good precedent. Our elected officials need to be able to carry out their jobs.
But if the elected official believes that she is in fact biased, whether or not she should be or shouldn't be, isn't she required to recuse herself at that point?
That would be, we would submit that again, it's still not enough to meet the high standard. Sure, you can recuse if you feel that you need to, but if there was no manifest necessity for it that meets what that term of art is supposed to mean in the law, then the consequences, jeopardy must attach. So if at the end
How much of your argument turns on the fact that she didn't really elaborate on the reason for the recusal?
We would submit that is the cleaner way to go about this case. You can avoid the thornier issues if you adopt the Klein versus Lice rationale. And in fact, this court in State versus Duthard, which was, I think, a 2001 decision, it's been a while since it's been addressed by this court. But Duthard is cited in our brief. And Duthard says at least some effort on the part of the trial court to explore alternatives must be apparent before a high degree of necessity is demonstrated. And we have none of that here. Court was abruptly recused. I believe defense counsel tried to interject. You see a quick, Your Honor, court adjourned. So under those circumstances, we would offer that when the record contains no evidence that any of the Klein versus Lice factors are met, that a manifest necessity has not been demonstrated.
How much should we take into account the fact that, number one, this was a bench trial? Mm-hmm. Number two, it wasn't that far along in the bench trial. Number three, the state did nothing to provoke this. Number four, there's a victim in this case. I mean, do any of those issues come into play in our analysis?
So those are all factors. When you research the case law in depth, prosecutorial misconduct is one way. Well, prosecutorial misconduct that goads the court into granting a mistrial is one way where jeopardy clearly attaches. Then you have abuse of discretion is the separate analysis. Those are two different things. We submit that when it's a bench trial, actually you don't have the optics of a jury and things looking unfair in front of a jury at play. So it actually should be a bit harder to find manifest necessity.
But you have the judge who now has to determine guilt or innocence.
You do, but judges are, expected to apply the law, to rule with detached. One of the judicial rules says something about the judge shall be available to hear cases assigned to that court. So we're to assume when it's a bench trial that those, again, the rules are followed, you know. As far as the victim not getting their day in court, again, that is going to be a consideration in every double jeopardy dismissal. That's taken into account in the Widner case, the second prong, that I couldn't find a single case that turned on the ends of justice being defeated. But that is actually what that prong speaks to, is the public not getting, through the prosecution, not having a chance to have their day in court to present a full case on the merits. And again, the only case, I found one where the ends of public justice was the finding, and the name escapes me, but it was where a procedural error will guarantee a reversal on appeal. Say there's a defective indictment, and there's no reason for trial to proceed, and then get reversed on appeal and then go back. So that's an end of justice finding case, and that's where jeopardy will not attach under those circumstances. That's the only one I could find. All the cases either talk about manifest necessity or conflate the two concepts. So all these considerations are present, but we would again hold that, under this record, and one other point that I would like to make is that, as appellate practitioners, we know that plain error review is kind of the death knell to most arguments. So if our attorneys don't raise these things, don't raise, this is what the law dictates, whatever, make these arguments, we pound into their heads, make a record. So we do want our attorneys to raise these arguments, even if they disagree with the judge, to say this is what the law is, to make a record for us.
I want to go back to your point about considering other options.
Yes.
Like, that seems to make sense if there was an error, like someone tried to get in evidence that had been excluded, then you can take measures to try to mitigate the impact of that. But in a situation where the judge concludes that she's so biased that she cannot proceed further, like, there's really no other options at play at that point, right? Or are there?
I would respectfully disagree, Judge. Never having sat on the bench, I can only guess, though. But, if tensions are getting high, which I would submit happens, somewhat regularly across the street, there is the option of declaring a recess, letting everybody cool their heads. The judge can go back and throw darts at a dartboard with the attorney's picture, whatever. But declaring a recess, even calling the attorneys in chambers and saying, I don't like this, cool it off, whatever, having that discussion off the record. And I've seen case law where the courts do exactly that, go off the record. I believe it was the Clark case out of this court, and I don't know if it was cited in my brief or not.
Ms.
where-
Gieske, you are about at your time. I'm going to let
Okay.
you finish this
I
argument
will.
because it's in response to a question.
Okay, so the Clark case where they did go off the record, have a discussion in chambers, and then come back on and put that discussion back on the record. Taking those steps rather than just quickly, abruptly, creating a record for this court and for everyone to go ahead and put that manifest necessity on the record, rather than just having all of us guess. Courts abhor speculation, and we would urge you not to go back on that now. So
Let me
all
ask you one
reserve-
follow-up,
Sure.
and it won't count into your rebuttal time.
Okay.
If it weren't because she believed she could not fairly hear the case anymore, is there any other reasonable inference that could be made, or is that the only reasonable inference that can be made about why she declared a mistrial?
I think that you don't even need to infer. The language is, I don't like you telling me what you have to do and not do. We're not getting along. I think that is telling. We are not getting along. And is that enough? That's what this court has to decide. Is a judge and attorney not getting along enough to rise to manifest necessity, which is this super high bar? We would submit that it's not. Thank you.
All right, thank you. Ms. Lapp, Mr. Souter, I don't know who wants to begin.
May it please the court.
Do you want me to stop you at any point in time, or will you just keep going even if you use the 15 minutes?
Oh, definitely stop me.
All right, at what point would you like me to stop you? So to give Mr.
Seven
Seven?
minutes?
All right, whenever you're ready.
All right. I don't think I have a whole lot to say more than what I put in the brief. I think when you read the transcript, it's obvious, I think the judge did show great restraint The judge was trying to be patient and explaining her reasoning. She was not rude to the attorney. She did call a recess at one point. And then when they came back on the record, she ruled in favor of the defense at that point.
I guess I hear what you're saying, but I guess my struggle reading the transcript is I see, maybe some, comments that should have been tempered a little bit, but I don't see anything that is like, oh my goodness, that cries out as something that would trigger a mistrial, something that would trigger prejudice on the part of the judge. And without the judge saying, I have such bias that I need to recuse myself, like, what are we supposed to do with that?
I've read the transcript so many times. A lot of the comments do shout out at me so many times, just defying the judge's rulings. A judge isn't going to always be right, but when they make a ruling, you have to accept it, and you can speak respectfully, but then you have to move on. And so many of these comments were that's not how I do it. I wasn't trained that way. We don't do this. And it was repeatedly not accepting the judge's rulings. They say that because with the transcript.
Oh, but it's not the judge's rulings, it's the judge's kind of comments on how to do impeachment, for instance. This is not an instance where the judge says, here's my ruling, this evidence is admitted or this evidence is excluded, and then you have the attorney violating that. So it's not that kind of scenario.
Well, it's going to be your judgment on how you read the transcript and applying the law. But I think when the cases talk about the fact that because we're not able, or you or myself, to have been there to hear the tone of voice, the demeanor, etc., there has to be great deference given to the trial judge's decision on this. And I think that's...
Well, you're asking us to infer why she declared a mistrial, right? Because she doesn't explain why.
Yes.
So you're saying that because she got so frustrated with defense counsel, we can infer that she didn't think that she was fair and impartial anymore.
Yes.
Would this be different if it were a jury trial rather than what it was in this case, a bench trial? I mean, would this rise to manifest necessity if this were a jury trial?
I can't say whether it would. There's so many circumstances, but I do think because it's a bench trial, and it was just kept being repeatedly butting heads, and repeatedly, the attorney telling the judge, this isn't how I do it, this isn't how we do it, that rose to a manifest necessity. Because I think the judge, by calling the mistrial, was trying to protect her client. It was the attorney's own conduct that was going to be causing problems for the client. And I think that's obvious when you read the transcript, because it went on and on and on. Everything was very contentious from the attorney, abrasive almost as I read it. Now, I understand you're saying you don't read it that way.
Well, we read a lot of transcripts and we see a lot of contentious behavior and a lot of abrasive behavior. And so I think that's what I struggle with here is let's say that this went the other way. She did not recuse herself. And then the defendant gets convicted and appeals to us and says, oh, a mistrial should have been granted because the judge was butting heads with my counsel. I mean, I don't think that argument would get very far, do you?
It would depend on exactly what the transcript showed.
Well, say it's this exact transcript. I mean, we wouldn't reverse the denial of a mistrial on this record, would we?
I understand what you're saying, but I don't think that's the situation we have here, because that's asking, in the absence of something, would you make a certain determination? But here, you do have the judge, you've got the record in front of you, and you give deference to the judge's decision on this. And I think there's plenty in here to show why the judge made the decision she did, because it was repeated comments. She did call a recess. Every time they came back up, it was another fight with the attorney, telling the judge what to do, what she's going to do, how to do it. And I think it got so contentious that it caused the judge to feel she couldn't be unbiased.
You have about 1 minute left if you'd like to give 8 minutes to Mr. Souter.
I would just be repeating the same things over and over. I think the judge showed restraint. The judge was patient. The judge took this. There were 4 or 5 separate exchanges. I mean, you have the transcript, and I know you'll read it. And it got to the point where there was just no point in not declaring a mistrial because of what was happening. And
Thank you. Mr. Souter, you have 8 minutes.
Thank you, Your Honor. Can't imagine I'll take that long. Ms. Gieseke didn't have the opportunity to address the writ, so I'm not going to spend too much time on it. And I don't have a lot to add to what I put in my my written motion for summary judgment in this case. This just seems like a classic case where a nunc-pro-tunc entry was proper.
Let me ask you this. Didn't it add something that would make it not a nunc-pro-tunc?
I didn't see anything that it added. The only gloss on what happened at the trial was, excuse me, was based on defense counsel's statement. That's the only thing that's added. Excuse me, and I just don't think that changes the substance of what happened at trial.
But the problem with the order is the judge has recused herself because presumably she's so biased that she cannot proceed further.
Right.
And then she's entering orders afterwards. Like that seems problematic.
Well, and I think that's the essence of a nunc-pro-tunc. It's a now for then, that she just wanted to indicate to memorialize what she had done at trial.
But she'd already memorialized it. I mean, that's where it either, to Judge Meyer's question, it's either adding something or it's not. And if it's not, what's the purpose of it? And if it is, that seems problematic.
I think it was a belt and suspenders kind of a thing. She was concerned that the record wouldn't reflect via a journal entry that the mistrial had been declared. So in an abundance of caution, she put it in a written journal entry. And
what was the timing of that? The case was re-rolled, right? And it was in front of another judge?
That's correct, Your Honor. The case had been re-rolled. She recused herself on May the 3rd of 2021, and the motion for the motion had been denied by the motion for double jeopardy motion had been denied by Judge Bender on May the 27th, and then this nunc-pro-tunc entry went on roughly 4 or 5 days later. It was on.
Was it at the suggestion of the prosecutor?
It was, Your Honor.
Okay.
Yes, I think the prosecutor wanted to ensure that there is a record established that was the basis of why the trial had terminated to begin with. There's ample case law out of this court and out of the Supreme Court of Ohio that the writ of prohibition is to be issued with great caution and only in cases of extreme necessity. I don't think that's been shown here. First of all, as I indicated in my motion for summary judgment, I don't think there's been any showing of impropriety. What the judge did was simply a memorial to memorialize what her ruling had been on the day of trial, and and I know that there is some case law indicating that. Excuse me, I'm sorry. That the presence of a remedy at law is not necessarily fatal to a motion or a writ of prohibition, but in this case, I think it's clear that what the court has to sort out in the appeal really subsumes everything that's included in the writ, and I really would not see any point in having an extraordinary writ issued under these circumstances. The court has no further questions. That's all I have.
Any questions? Thank you, Mr. Souter. Ms. Gieseke, you have 3 minutes remaining.
Thank you, Your Honor. I don't want to beat a dead horse, so I'm not going to spend a whole lot of time on the interlocutory appeal. Just to respectfully correct counsel, there were 3 exchanges, not 4 or 5. It was the motion in limine-esque pretrial exchange, the opening statement sua sponte remark, and then the impeachment snafu. We would still submit that you have to read that nasty tone in, that is not present. I think Judge Bergeron, you had alluded to, counsel maybe didn't use the buzzwords, respectfully, Your Honor, yes, Your Honor, at most. Possibly blunt, but not nasty. And the discretion, as counsel said, is broad, but it is not unbridled. The law does not condone that. There have to be some guardrails on it. And we would submit again that mere disagreements on the law are not enough to rise to manifest necessity. Regarding the writ case, I think that is fully laid out in the pleadings, so I won't go too far into that. But just to, respectfully comment on Mr. Sauter's arguments, the nunc was not proper. Merely saying mistrial granted, that would have been a proper nunc. The judge did say, I'm going to grant a mistrial, you can re-roll it. That was fine. It was this adding the substantive reason that is clearly outside of a nunc's proper function.
Was the mistrial indicated on the judge's sheet?
Not the first one. So court recuses re-rolls was the entirety of that one.
Okay, so all there was at that point was the transcript.
Right.
Okay.
Right. So we would say that is proper. Anything beyond that is not what a nunc is for. And as for the argument that, yes.
Wait, you're saying that it would have been proper if the nunc pro tunc had just said mistrial granted?
No. That would have been the proper use of a nunc order.
Okay.
Just to correct, that would have been more of the clerical error. There still is the fact of recusal. I don't, that's the more sticky wicket. I don't think that a judge can, the tissue case out of the 8th District Court of Appeals says that any acts by a judge after they recuse are voidable, subject to timely. And we filed this writ 2 weeks after the judge issued the nunc, so that would be a timely objection, we would argue. And Mr. Sauter is correct that writs are an extraordinary remedy, but we would submit that when a judge does not follow the law or the rules of court, what other recourse do parties have than appealing to this court's supervisory jurisdiction? And under that law, I believe it is the Adams versus Gus Weiler case out of the Ohio Supreme Court that was cited in our petition. One of the reasons for a writ of prohibition to issue is this court's supervisory jurisdiction to prevent usurpation of its jurisdiction by an inferior court. And once our final order, we appealed the denial of the motion to dismiss the same day that Judge Bender ruled on it. That froze that in time for the trial court to undergo any action except in aid of the appeal. That is appellate practice, 101. Those final orders cannot be disturbed, especially adding substantive reasons. So, yes.
And you are at your time, Ms.
Okay.
Gieseke, unless
So we would
the panel has
just
any
request.
questions.
Thank you, Judge. We would just request that the primary relief requested is that, of course, that you reverse and remand with instruction to discharge Mr. Hare, or ordering the motion to dismiss granted, and alternatively to issue a writ of prohibition vacating the nunc pro tunc entry, supplementing the court's first entry. Thank you.
Thank you. Counsel, thank you all very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. Our next case on the docket, we will take a brief recess before we call that case. We need to switch the panel. So we won't leave the courtroom, but we will take just a brief recess before we call the next case. Welcome, Judge Zayas. Our final case to be argued this morning is Fox Consulting versus Mailing Services. Mr. Englert is here on behalf of appellant. Mr. McSherry is here on behalf of appellee. Mr. Englert, would you like to reserve any time in rebuttal this morning?
Yes, I would, Your Honor. 5 minutes.
All right. Whenever you're ready, you may proceed.
Great. Good morning, Your Honors. May it please the Court. It is good to be back in person. Glad for that. So this is a commercial contract case that comes before the Court in the posture of a motion to dismiss, and that's the whole key to it. And I think that in the ruling in the trial court below, there were some, we pointed them out, some fairly egregious errors of law. So, for example, it was a very brief opinion and very brief kind of analysis as to, whether there had been a breach of contract. And at one point, the opinion says that, Fox wants compensations for savings realized. However, Fox, my client, only assumes mailing services, defendant, went to a third party. Fox failed to present any proof that mailing services utilized a third party to implement any of its cost savings recommendations. So, I mean, it clearly gets the standard wrong for Rule 12B.
But isn't what, I mean, the judge it looks like he's referring to paragraph 6 of the complaint where it says it is believed that they went to a different vendor, right? So that's the assumption.
Correct.
That the judge is referring to. And my question is that enough in a complaint to base it on speculation, or should it have been more of an allegation that they in fact went to another vendor?
Well, Your Honor, I appreciate that, but I think that in this case, we did not have all of the knowledge about what had actually happened, and that's something that will happen in the later on in the case. If we have discovery, we'll find out exactly what happened and exactly what the damages would be. But in this case, there were indications that this is what has happened, and so the way that it is framed here is that it says it's believed that defendant chose to do this, and so that I think that under the standard, if you draw the inferences in favor of the non-movement, what we are saying is that under this contract, they are not allowed to go to another vendor once our recommendations have been made, and that's very clearly set forth. And so we are saying that
they may have gone to another vendor, but not that they actually did.
We're saying that, Your Honor, if we had to rewrite this, we would not include the words "it is believed," and we would just make that assertion. But I think, though, that if you look at, I mean, as Your Honor knows from that case, maternal grandmother versus Hamilton County Department of Jobs and Services, I mean, Ohio remains a notice pleading state. And so, I mean, the essence of it is, have you put defendant on notice of what the claims against it are? And I think that we clearly did that, in the language of the complaint, and even in that paragraph there.
Would you agree that really that it's another way of saying upon information and belief, we claim X, Y, Z?
It is clearly that. It is believed that. That's the language that we use there. Also when you think about, we attach the complaint, the contract, we attach the recommendations that were made, and we attach their acceptance of that proposal to the complaint. And under Rule 10C, if there is an attachment of that instrument, then all parts of that contract and the attachments are as if they are stated in it. So we bring attention to what we think is just the absolute crux of the issue here.
Would you agree that if we agree with you that the contract governs this case, that the court was right in dismissing the quantum error claim?
Yes. Yes, Your Honor, with some exceptions. I guess if it was never raised in the briefing at that point, but if it were to be argued that the damages under the contract did not apply somehow, that they were against public policy or who knows what, in that case, we think that there would probably still be a claim for quantum merit for the value of the services that were rendered there. So that's why that is in there. But certainly.
Well, that would negate the contract, though. Wouldn't that be a finding that the contract was against public policy? I guess maybe I'm asking even a more basic question, which I think you did answer, that if the contract does govern it,
Yeah,
then
I think it's
the
an either
quantum merit
or.
claim is gone.
Yes, I think it's an either or. If there is a contract there, then that's what does govern. And again, I think the plaintiffs didn't argue that this was ambiguous. They didn't argue that it was against public policy. The contract itself, you've seen it. It's 14 paragraphs long. It's pretty direct. And I think that all of the elements of stating a claim for breach of contract is in there. There is a contract. There was performance. I want to talk a little bit about this matter of performance because it goes to the issues that may give some pause to the court in applying the remedy that we're seeking, which is that even if MSP doesn't go with our recommendations, then they go to somebody else. The contract provides that the savings that are realized as a result of going to somebody else will be attributed to Fox. And the reason for that is I use the analogy in the brief that it's sort of like a renovation of a house, and you need an architect to do that whole renovation. You need a general contractor to carry it out. In this case, Fox is both the architect. It provides the plan, and then it's the general contractor because it then goes to the Verizon, Comcast, whatever, and then comes back with the actual contracts that carry out its information. But like the architect, we provide the plans. And the plan, if you look at that recommendation proposal, there's 35 pages of analysis there. The first thing that we do is we go to the client and we tell them what they have exactly. And this client had 3 separate locations, multiple phone lines at each one of those. We analyze every bit of that. And then we say, there are lots of ways that you can go about savings in it. And then we give them 3 separate proposals. And like the first one, which is the one that they accepted, it actually involves like changing from an analog to a voice over internet protocol system. So there's a lot of information in there. And what our client is a consultant, what he does is he provides ideas. He gives information. He gives what the architect does when a house is being built. It's an entire plan. And so if like the homeowner gets these plans and they say, oh, this is great, and I can be my own general contractor, or I can hire somebody else to do it, and then uses that information, well, that's an improper use of that intellectual product. And so that's what we state happened here, which is that
you have about a minute left.
About a minute left? Okay.
If you want to reserve 5.
Yeah. Time does go by. So the paragraph 8 actually contains 2 clauses in there, which constitute that they state what a breach is. The client warns that they will not duplicate the work carried out by Fox, nor will the client negotiate alternate pricing for telecom services during the term of the agreement. So that's what we say happens. That is the breach. And when they went to somebody else, that is the injury to my client. The amount of the damages, the final part of this puzzle, those are to be determined. They're based, we say, on this paragraph 4. Once this agreement is signed, any client savings realized shall be attributed as a Fox initiative, so that they went to this other person, they obtained the savings of $60,000, $70,000 a year. Under the contract, we get half of those. That measures the damages, but the actual sort of injury is the fact that they breached the client by going to another party and deprived us of going through with the recommendations that we had made, which is that actual implementation is when we make money on it.
All right,
Thank you, Your Honors.
thank you. Mr. McSherry, you'll have 15 minutes.
May it please the court.
Let me start, if I could, by asking you a question. Would you agree that the contract provides what Mr. Englert said, and that is that it prohibits your client from directly negotiating with other vendors and with implementing other people's, or implementing ideas?
I know you're paraphrasing. In part, it says that.
And let me ask you, if that's true, then why isn't paragraph 11 and 12 of the complaint sufficient to allege, whether or not it can be proven another thing, to allege that breach?
Well, first, they do state in part that you cannot negotiate with another vendor. But the missing part to that appellant forgets is that as part of that, then there must be implementation and savings realized. I mean, they've got part
Well, they've
of it.
alleged that, haven't they, in 11 and 12?
They have not. They have not. What they've alleged is basically a warning shot. As Judge Krause pointed out, these are affirmative allegations that need to be made in order to establish a breach of contract. Contract exists. There's been a breach of a particular provision, and that there's resulting damage. What they've alleged is this: under the contract, in paragraph 6, they say, rather than moving forward with the implementation of the savings recommendations, it's believed that they chose to negotiate with another vendor, which, when implemented, will result in savings. So 2 key factors there. Under the express language of the contract, there has to be implementation of their architectural plans as they describe them. We never took their architectural plans. They've never alleged that we actually implemented their plans or their recommendations. And
Well,
secondly,
doesn't the
haven't-
contract also say, though, that your client can't go out on its own? Put aside whether it implements it. I mean, isn't the breach when your client does the act?
But they haven't alleged damage resulting from that.
Well,
What
they've
they've-
alleged it, they haven't proved it.
They have not alleged it, and based upon my reading of the complaint, they have not alleged that. And I think that's what Judge Triggs, the trial court, pointed out.
Are you saying this complaint maybe is premature because they're anticipating that because you didn't go with them, that your client is probably going with another vendor, but that your client's not realizing savings yet because it doesn't allege that they actually went with another vendor?
That is exactly what we're stating, which is they're the master of their complaint. Under 12b-6, the court is supposed to take all their factual allegations as true. Under their factual allegations, they say there's been no implementation of their proposal by either my client or by a separate vendor, nor has there been any savings realized by my client by virtue of either them implementing their recommendations or someone else doing that. So
What
they
about
are
the
alleging a potential claim.
What about the declaratory judgment claim, though? Isn't that asking the court to declare that, and you wouldn't have to have current damages, would you?
I think you do need to set forth a claim for breach of contract in order to have a DEC action. So I don't think they've met that burden for the DEC action.
And
The
so you're
court only
saying
deals
that
with
the
actual
missing-
controversies in a DEC action. And there's no actual controversy because they're not saying that any damage has occurred because there's been no implementation of their recommendations either by MSP, my client, or by another vendor for MSP.
Well, but, I mean, you can have anticipatory breaches of contract, and you might not be able to quantify the damages, but that doesn't mean there aren't damages.
They have not alleged damages based upon this complaint that they drafted. They're the master of the language that they chose to employ in their contract. We are not.
But how does that go with notice pleading, though? I mean, what they're arguing is that, the essence of this contract, basically, maybe it's inartfully worded, but that your client went with another vendor and it is realizing savings and owes them money under the contract. I mean, isn't this complaint enough to put your client on notice that that's what the allegations are?
I think without question, it is not. It is not sufficient.
Why?
because it's all based upon this has not occurred yet. They even say in there, there's only going to be savings occurred potentially in the future. They filed this in March of 2020. They put in there that these savings may occur as of May 2020, like 2 months later. So it's a warning shot. It's not affirmative allegations that a breach actually occurred.
How would they know, though? All they know is that your client didn't go with them. So if you're not going with them, you must be going with somebody else.
They need to make that allegation. If they believe there's been a breach of contract, they need to make that affirmative allegation as against my client. They have not done so because they know they didn't. They know that's why they were afraid to make that argument or that allegation as against MSP. They filed this as a warning shot to my client. And they did not assert a breach of contract claim, and it's very evident from the language they use. They haven't implemented the recommendations, and they haven't realized any savings yet. But it's going to happen. They're predicting it's going to happen in the future. It's more in the line of a motion for a temporary restraining order, which wouldn't meet the elements, but it's really, saying, hey, don't let this happen. It's not saying the contract's been breached. It's saying this may happen. We've got a claim.
But under paragraph 4 of the contract, isn't the contract breached when your client goes outside of the contract? It says that the client acknowledges that our activity on your account may trigger offers directly from existing or alternative suppliers. The client agrees to refrain from entering into any new agreements or negotiations in the targeted category. Once the agreement is signed, any client savings shall be attributed as an SM initiative. Doesn't that prohibit your client from doing anything that would violate that paragraph? And isn't that the breach?
That's what they're alleging, the breach, but there has to be associated damages alleged. In their next paragraph, paragraph 7, after they say, we believe that they chose to negotiate, although there's been no implementation, no savings realized, we're entitled to payment of 50% per the contract. So that's the payment terms portion of the contract.
Wasn't that the damage, the alleged damage?
That's not the damage because implementation has not occurred as acknowledged in their complaint, and savings have not occurred as acknowledged in their complaint. Again, they're the master of the language they chose to employ in their complaint, and the court is only supposed to, 1, take their factual allegations as true. Those factual allegations don't rise to that level.
So negotiation with another vendor would be a breach. You're just saying that they didn't allege damages because they can't get damages unless your client actually realizes savings.
They could allege that is a breach, negotiation.
That would be a breach.
That's what they claim.
Okay.
But the missing piece to that is their next allegation is we're entitled to 50%, but in order for that to occur, for damage to occur, there has to be implementation of the recommendations and savings realized. The only thing I would say in addition to that, so on the trial court's decision where it used the word proof, I mean, clearly the trial court recited the correct standard, clearly didn't request an evidentiary hearing, did not consider anything else other than the briefs that were filed, the motion to dismiss, the memo and op, and the reply memo in support of the motion to dismiss. My concern is if this case were to get remanded, it would be the same issue. I would just ask for an instruction if it did get remanded to ask the trial court, hey, address this issue. Did you rely upon proof outside of what the parties briefed, outside of the complaint allegations? Because I think the answer is going to be the same, is they still have not stated a claim. And also, they didn't file a Rule 15 motion for leave to plead or to amend their complaint. They did not ask for that. They flew with what they had alleged, and they didn't even use the word breach in their complaint.
Well, the heading is breach of contract.
Yeah.
For the claim.
Right.
I mean,
Then,
they have two
but,
claims.
yeah.
One is breach of contract.
Right.
So I think in fairness, they did allege a breach of
Well,
contract.
it's in the heading. I agree with you. So other than that, the other issue is you've already addressed it. We don't believe there's a quantum merit claim when there's a express contract in place, which they allege. That's all I have.
All right, thank you. Mr. Angler, you have 5 minutes remaining. Can you start by addressing Mr. McSherry's point that the complaint is not sufficient to allege damages, and point us to where you believe it is?
Yes, I mean, I think that the complaint itself does not it can't get into damages at this point. The reason that we use the sort of future or conditional language is that in the recommendation and proposal, there is it shows when the existing services, when those existing contracts end, and it's the end of May in 2020. We filed this in March, so those contracts were still in place, the existing ones. And any new proposals, ours or another party that they went to, would start at that time. So it's we asserted that there was already the breach, and the breach carried with it the injury that we were then deprived of the right to the future damages that would happen, once the new contracts were in place.
But it seems as if the language of the contract, so let's say that we do agree that there was a breach of contract, okay?
Okay.
Then we get to damages. Seems like the damages required 2 conditions precedent or 2 contingencies before you even get to damages. The language, how would you distinguish that language and say that it's not speculative in your complaint with regard to those contingencies?
Well, first, I mean, the matter of implementation, I mean, that only arises in the payment terms. It's purely a matter of when, once the new contract is in place, then the savings will start to be realized at that point. And then those are our actual damages. The injury is that we no longer have a contract. We no longer have this performance. We no longer have.
And let me just make sure I'm clear. So looking at the language, there has to be an acceptance of any initial or supplemental recommendations, and there has to be then savings realized as a result of that.
Yes, and so the recommendations were accepted. That's the last page of Exhibit 2. It's this authorization to proceed. Schooling Mitchell would like to thank you for the opportunity to provide this comparative analysis for your consideration. If you agree with our recommendations for your telecom needs, please authorize Fox to perform the necessary changes by initialing in the boxes below and signing and dating the bright yellow highlight box. Okay, and then there's a signature by the Vice President of Finance of Mailing Services, who agrees to option 1. And option 1 was the plan where they changed to the internet service protocol. The savings realized there on a yearly basis were $67,000. So they were accepted. That's one of the conditions. And then the date of implementation, that will begin on May 27th, which is when the existing contract ends. And I mean, we have to assume that Mailing Services of Pittsburgh is going to continue to have telephone services. I mean, that's certainly going to continue. And until that time.
I guess what I'm struggling with is the language in the complaint that it is believed and implemented. And I'm trying to distinguish that with it being just speculative.
Well, I don't think it's speculative because, I mean, there's a very thick context here of information. I mean, we know what is happening. We know that there is going to be this new contracts that go into place. The old ones are ending. So it's not speculative that those are going to happen. And, you know, we say.
Not speculative that there will be savings realized based on your pleadings? That's what I'm trying to figure out.
Okay, say that again, Judge. I didn't
Okay.
quite-
With regard to your pleadings, it seems as if the language is speculative.
It is not speculative, but it is in the future. The savings do not occur until the future. And it's not speculative because they didn't go with us. They're going to continue to have internet services, and they went with another party. And that was the breach. The injury follows that. The amount of damages are still to be quantified. But I submit that they're not speculative, that rather they're simply in the future. And when if this case is remanded, then we'll get the new agreements that were signed. We'll find out like what the amount of savings is on that. I mean, we believe that there would be savings and that those would accrue to them. And so I'm not sure if I'd answered your question.
You've answered
but
my question.
It's
I
not
appreciate it.
speculative,
You've
it's
answered my
still in the
question.
future.
Thank you.
Okay. Any other
As
questions, Your Honor?
as a practical matter, if there have been savings and if it has been implemented, those happened several months ago. Now that we're sitting here today.
Yeah, today we are, almost 2 years into the new contract. So that, you know, by this time, you know, unless they somehow did not receive any savings in their new contract, which we think is unlikely, given that they had this information, they accepted this proposal, and they had to somehow have telephone services. So we would ask that the court, you know, remand this so that discovery can take place, and we can know exactly, you know, what how the injury occurred, how the breach occurred, and what the damages are.
All right, and you are at your time.
Okay. Thank you, Your Honors. Appreciate it.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. That will conclude the First District Court of Appeals arguments this morning.